to the ICC in Paris and acted as counsel. Jacqueline, sorry, I should say, has just started recording, so just so everybody knows that this is being recorded. So he has both the institutional experience of the case management side from his time as counsel at the ICC in Paris, he is now obviously head of international arbitration for Asia Pacific at White & Case up in Singapore. A rare thing for this part of the world. He's both a civil and common lawyer, and he's author of a book called Interest in International Arbitration. So that's why he's our expert today. I know most of you who are on this call. For those of you that I don't know, my name's Daisy Mallett. I'm on the ICC Australia steering committee, and I am an independent arbitrator and have spent the last 20 years focusing on international arbitration. I had to check that the 20 years was right when I was writing that down, and sadly it definitely is. I was formerly a partner at King & Wood Mallisons in Sydney. So with that, we're going to dive straight in. A little bit of a précis of the topics we're going to cover before I jump into the questions, and obviously feel free to add your own into the chat. And if you really can't help yourself, please jump in as we're discussing as well. We're going to cover why lawyers don't like interest, an important one. We're going to look at common misunderstandings on interest. We're going to talk about conflicts of law, and also advice to counsel and advice to arbitrators on matters of interest. So with that, Matt, interest is a topic which you and I both think doesn't get the attention that it deserves. So there's a real risk that as with our counsel hats on, people are leaving money on the table by not claiming the full scope of interest that they might be otherwise entitled to. And as arbitrators, that interest may not be properly being awarded. So tell us, why do you think this topic gets so little attention?
Thanks, Daisy, and hi everybody. Good to see you all. I appreciate any opportunity to talk about interest, because I think it's something we should talk about more. Why doesn't it get attention? I think there's a very obvious answer, and there's a less obvious answer. And the obvious answer is kind of a half truth. The less obvious answer, I think, is the greater truth. I think that the obvious answer is that lawyers just don't like maths. They don't like economics. And I think there's an element of truth to that. I think that lawyers are not trained. When you go to law school, you're not trained to deal with these complex economic and accounting topics. So naturally, you're not necessarily good at it. Just because you're a good lawyer doesn't mean you're good at maths and the things that you need to treat interest properly. That's obvious. The less obvious truth actually is about history and religion. For various reasons, and you can read this in my book, there's always been a historical animosity towards interest that kind of came up thousands of years ago, and it's kind of echoed through history. And for that reason, I could explain briefly, if you'd indulge me, people can have this natural icky feeling about interest. They feel that interest is something which is kind of ill-gotten. And the kind of the summary of why that is, you have to go back, thousands of years to the very early origins of history of interest. And just to give you a little historical tidbit, that interest existed for about 2,000 years before money did.
How are you? Yeah, I'm good.
Sorry, somebody's got there.
Okay. Did you get some good sleep? Did you get back to sleep?
Sean, do you mind jumping onto mute for us? Thank you.
Yeah, so basically the thing is that early interest kind of made sense because it was in productive assets before money was existed. So it was in grain or cattle or things like that. Then, money was invented and people started charging money on interest. But of course, people are naturally really greedy, as it turns out. And people kind of overextended themselves. So from the earliest laws we have historical records of, there was some type of protection against abusive lending. Okay, now that was a good policy, but the problem is, for various reasons through history, people started to get this feeling that interest on non-productive assets was inherently evil. And I'll give you just two examples from history just to illustrate this. The first is, believe it or not, Aristotle. So basically when the Mediterranean domination of, the Greek domination of the Mediterranean started, Aristotle was a very influential thinker. And he really believed deep down as a philosopher that interest on non-productive assets was evil. Now, just to fast forward, I mean, this was picked up in many ways, but through the Dark Ages, Christianity went on a warpath against a lot of things, but one of those things was interest. And if you take, say, for example, the writings of Dante, for example, he put usurers, so people who charged interest, one ring worse than murderers. So basically what you have is a situation that there's this real historical kind of animosity towards interest. And it wasn't really till the Enlightenment, and particularly Bentham and other Enlightenment thinkers, that this kind of idea that interest wasn't inherently evil kind of changed. Now, why do I say this now? Because I think a lot of laws which are kind of absurd or have some kind of like very loose or non-relationship with the real economics of interest, partially because of, as I started with, this kind of ickiness. People think that interest is not fair somehow. I don't think that's right. But I think that explains a lot of irrational laws.
One of the things that you talk about in your book is the etymology of the word usury, which was that where more is asked than is given. Yeah. And I thought that was so interesting. That's sort of, I guess, goes to this idea that people feel like it's somehow inherently unfair. And yet you talk to a commercial client, and if they've been out of money for 3 years, they feel like they've lost more than just, the original ticket sum of what was owing to them, not being able to use it in that period.
Yeah, no, that's exactly right. And I always analogize that if you rent a car, you expect to pay for it, even though you only have it for a week and give it back. But somehow people don't feel the same about, having money for a week, where in fact it's exactly the same.
Yeah, interesting. So your book focuses a lot on the economic underpinnings of interest and how that interplays with interest granted on awards. As lawyers, are we going to have to dig into the economics to get our decisions, or as counsel, our submissions right?
I mean, yeah, the answer is yes. I mean, there's actually kind of a tension between law and economics. And the reason why there is a tension is because, generally laws have as a policy goal when it comes to interest, they say that it's the C word, it's compensatory. Okay. Now, as an economist or as an accountant, you can actually work out what compensation is. You can actually work out the time value of money using economic principles. And the problem is, of course, the law doesn't necessarily achieve that. And I think we'll probably come onto the law a little bit later. But I think, if you're a lawyer to treat interest in a sophisticated way, you need to know the economic underpinnings because of that compensatory element. So just like damages, you can actually measure properly in a real, robust, meaningful way what the time cost of money is. And I'll give you 2 examples of what you need to understand. I mean, the first is, this may seem obvious, but a lot of people don't get this right, is the interrelationship between currency and interest rates. And the fact that depending on the currency that you're dealing with in the award or the claim, interest rates can be radically different. So you end up, people say things like, they say, 5%, that seems like a reasonable interest rate. They just, lawyers will say things like that. And there are lots of awards where people just say, I think 5% is a reasonable interest rate. But the thing is, if you granted 5% interest on an award today, that could either, depending on the currency, massively overcompensate the claimant or massively undercompensate the claimant. So for example, if you granted that in Swiss francs today, that would be massive overcompensation. But if you granted 5% on Indian rupee or even British pounds, it would massively undercompensate. So the idea that there's no kind of inherent nature of rates is something that lawyers just don't necessarily get. They don't get that you can come up with this idea of a reasonable rate. And it doesn't help that a lot of laws just say you should grant a reasonable rate. And that's quite a complex thing to calculate. The other thing is compound interest. I mean, this is a big thing in law, the nature of compound interest. And it's the one thing that I ask that you take away from this. And I don't mean this facetiously. This is not hyperbole. Simple interest is something that lawyers made up. It does not exist in the real world at all. And
Matt, can I just interrupt you there and just ask you to go back to basics for us and just remind people of the definition of simple versus compound interest?
Yeah, sorry, Daisy. It's true. That's a very, very good point. So the difference between the two is that simple interest, and it's very unfortunate it's called simple because people tend to like things that are simple, just means that it doesn't matter how long the interest runs, the interest only accrues on the initial principal. So if it's $1 million, it doesn't matter if the debt is unpaid for 10 years, you only ever get whatever the interest rate is on that $1 million. Compound interest is just the idea that basically after a certain amount of time, which could be a day, a month, a week, a year, or whatever, then you actually recalculate everything and charge interest on the interest that's already accrued to that date. Now, the difference between the two, as I say, is that compound interest is accurate. Simple interest is inaccurate. Okay, now you think, a lot of lawyers will immediately think, but just a second, simple interest, why not? Because if I say it's 5% interest and it's 5%, it continues to run at 5%. That's fine. But of course, that is not true at all. In terms of real economic returns, if you grant simple interest, what actually happens is the actual return decreases over time because of the effects of inflation largely. So if you want to actually accurately compensate somebody for the time use of money, you can't calculate, except for very short periods, accurately using simple interest. It's just an economic fact. It's not something that I'm making up. It's just the truth. And you see this because nothing in life, nothing in nature, I should say, runs in straight lines. Like if you look at any development over any time in nature, it runs on a curve. It doesn't run on a straight line. And that is why I say that simple interest is something that lawyers made up and compound interest is accurate. And again, this is the type of economic thing you need to understand.
And there's a great couple of graphs in Matt's book that depict this very clearly on how that actually works, the comparison of what the time effect is on money when you have compound versus simple interest. That is definitely worth looking at. Jacqueline, could I ask you to put out our poll very quickly, please? And for all of you attending today who are sitting at a computer, Jacqueline's just going to put up a brief question asking you about your experience as counsel or as arbitrator in how regularly, in whether you've had cases where compound interest is awarded. I can tell you Matt refers to plenty of cases in his book where compound interest has been awarded, but I suspect once we see the poll question, it will be interesting to see how many, what the experience of the group of people on this call is. So we'll let that come up when Jacqueline gets a chance. And in the meantime, and I think Jacqueline will have to show us the results, but in the meantime, we'll... oh, here we go, poll. Can everyone else see it too? Okay, so submit your answers now and we'll show you the results. We've only got 3 results in so far, so we have to be a little bit patient. We're seeing huge, we've got a very small sample size here. But anyway, what we can at least tell from this sample is that there's plenty of people who, in all their experience, have never seen compound interest. And for those who have seen compound interest, my guess would be that it hasn't been in all their cases. So that comes out in your book, Matt. You're obviously an advocate for compound interest being both claimed and awarded, and lots of details provided in your book as to why that's the case. But you do note that often it's not.
Yeah, I mean, yeah, it's really funny because, a lot of people think compound interest is, again, something evil or something that's kind of wrong. And again, I think that once you understand the kind of the historical and religious nature of that type of superstition, I think that should help you understand, compound interest is just something accurate. It's not something extra. It's just how to make interest accurate over time.
Yeah, interesting. Could we also chat a little bit about interest rates? Your book goes into the distinction between borrowing rates and lending rates. Could you talk a little bit about which rates you think are appropriate and when?
Yeah, I mean, the things, obviously, there's lots of different ways of achieving a rate. I mean, obviously, people are familiar in a lot of things with using, legal rates and things like that. The issue really is if you're trying to prove kind of the proper compensation of a claimant, let's assume it's a claimant, for interest. And you can actually look at interest from two perspectives, in a sense, from a lender's perspective or a borrower's perspective. In the sense that it's what you would have done with the money or what it would take to actually borrow the money to replace the sum that wasn't paid. Now, obviously, one of the real differences is basically the credit risk of the actual creditor, which case would be the claimant in most cases. And the question is, to what extent do you take into account the specificities of that? And I do have some theories in my book about what this is, but it's not actually simple in any way, because my book kind of proposes a default method for dealing with this. But as I say, I can talk a little bit more about this, but in a sense, it's hard to draw a golden rule about which one is better. The reason being that, especially as counsel, you can actually justify either, depending on the circumstances. So, yeah.
So maybe that's the takeaway. Think about both borrowing rates, lending rates, and that there is, a number of different options that are available.
Very much so. If you're trying to prove damages of compensation, absolutely.
The next topic we were going to talk about was it goes to the topic of conflicts of laws. So a lot of lawyers naturally see interest as a legal exercise. Can you talk a little bit about how we should be thinking about interest in the context of an international arbitration as compared to a domestic arbitration, and the sorts of things that both arbitrators and counsel should have in mind?
Yeah, I think one of the things is that, when you have a kind of system of dispute resolution in kind of where you have everything aligned, so you have the kind of the seat of arbitration or the court, the applicable law, etc. It tends to gel. Because it tends to have evolved as a system that kind of makes sense. So that's all fine. In the international setting, sometimes you kind of shake things up so you don't necessarily have that alignment. And in the subject of interest, you come up with a rather unusual problem. And this is that it's hard to draw perfect parallels. It certainly doesn't apply all the time. But as a general matter, in the common law, interest is treated as a kind of question of what I would call procedural laws, and they deal with it in terms of the powers of the arbitrator to grant interest, which is a fundamentally procedural thing. In civil law systems, you typically deal with this as a question of substance. It's dealt with in the Code of Obligations, and it's in the realm of substantive law, not so that they don't have it in the part of the civil code dealing with, say, for example, court's powers. It's actually a question of substance. Now, why is this complicated? The issue here is that if you have an international arbitration where you have a common law seat and a civil law applicable, or vice versa, you end up with a funny scenario where either two laws claim to deal with the topic, or neither law claims to deal with the topic. So to illustrate, so here in my kind of professional home now in Singapore, imagine you have a Singaporean seated arbitration under Indonesian law. Very common. I do a number of these cases. In that case, you have two laws that claim to apply, because you've got Section 20 of the Singapore International Arbitration Act deals with interest. It says that arbitrators can grant interest. It gives them broad discretion, both dates, rates, and whether it's compound or simple. Fine. But then Indonesian law, the Indonesian Civil Code, also deals with interest. And it provides, generally under certain circumstances, that if there's a default, that interest is payable on a simple basis at 6% per annum. Now, here you've got two laws who the parties chose by choosing the place of arbitration and the applicable law, and they both perfectly claim to deal with the same question, and that's complex. And of course, if you flip those two things and had a Jakarta-seated arbitration under Singapore law, you'd have two laws, neither of which claim to deal with it. There's no real way of dealing with this. I don't propose a solution in my book, but it's helpful to know.
Yeah, very helpful. And I just noticed that we haven't really touched on contractual interest rates. But the new 2025 SEAC rules seem to me to introduce a new concept, which I don't think was there in the 2016 rules, but you'll correct me if I've got that wrong, requiring the tribunal to take into account any agreement by the parties on interest.
Yes.
I suspect you were involved in this provision being introduced, but is that really a nod to arbitrators to be taking notice of contractual interest rates where they're provided for, or is that really trying to do something else?
No, that's it. In fact, it's funny because there's many awards where arbitrators grant interest under the contract. I think if it's a straightforward provision that clearly applies, I don't think there's any question that arbitrators should grant interest in accordance with the contract. Of course, there's many examples when they don't, for some strange reason. Often, I mean, that's one of the things we can touch upon. But the quality of interest submissions is generally very poor, and the quality of decisions on interest are very poor. You know, and so you do get some odd decisions, but generally they're respected. There are some interesting aspects, though. So the classic thing which is interesting is when you have a contract that's kind of a complex contract, and it includes an interest rate and a structure for interest on certain payments that would be made under the contract, typically, for example, unpaid invoices, but doesn't deal with interest generally. And then arbitrators face the question, should we apply this regime not just to those particular sums, but to the broader, to other amounts that may be due under the contract? And arbitrators have answered that both ways.
Yeah.
I think there's a good argument to say, well, especially if it's a sensible regime, that the parties probably would have expected that it would have applied more broadly. But, you know.
And presumably the counter argument could be made that if it applies specifically to a certain type of payment under the contract, then it deliberately didn't apply more broadly.
Correct. Yeah, absolutely. Yeah.
Yeah. And your advice to counsel when drafting submissions on interest, I think you've got a couple of pointers for us. Can I just jump in with a question? In my experience, most of the time, interest doesn't get dealt with until post-hearing briefs. Would you say that, is that your experience, and should that be the case, or should parties be dealing with that at an earlier stage of their submissions?
Well, I think they should have dealt with it much earlier, because I mean it's a lot of money, I'd say two things about being counsel. One is that, first thing is that you've just got to realize the worth of it, and people know in the abstract the worth of interest, but they just don't actually think about it. So I'll just illustrate this. I think it's worthwhile. So if you take, say a $30 million claim, I don't know, it's just a random number that I picked. And let's say that there's 4 years between when the debt fell due and when it's ultimately paid. For each percentage point extra interest you get, that's about 1.2 million on a $30 million debt. Right? So if you can, as counsel, get interest up 1% on even a relatively modest claim like 30 million, you make more than $1 million per point. And that's why it's just shocking that people just don't do this. And people leave money, they leave millions, tens of millions, hundreds of millions of dollars on the floor when they could have easily, just by a little thought, made a lot more money. So would you do this early? Yeah, I would think you should take interest as seriously as you take damages.
Yeah.
And do it as early as possible.
And I think, particularly in circumstances where you already have one round of post-hearing brief, where, particularly as arbitrator, if you're only having one, if the parties don't have the opportunity to respond to the other parties' submissions on interest, it actually makes life more difficult for you as an arbitrator, I think, where there are, competing positions.
Yeah, I think that you should never have an interest claim without the opportunity for the other side to reply.
And just often it's done in such a shallow way where, there might be a claim for compound interest, but there's just not any analysis of why compound interest ought to be preferable to simple interest, or analysis of the rates proposed. It's just pure, it's very shallow, I think, often. as much detail on that as possible will serve clients better and arbitrators deciding the awards. What advice do you have for arbitrators?
I think there's a few things. One is, you need to encourage parties to make interest submissions early, because parties often fail at doing it. They claim interest, but they don't set out the parameters they need in terms of rates, dates, calculation methods, etc. So, I think it's one of these things where, arbitrators often get in trouble. And at the ICC, you often see this in context of scrutiny of awards, because what happens is a party makes an interest claim half-heartedly, and then it gets the drafting stage, and the arbitrators are drafting the award, and they get to the very end and they go, oh, I don't have any of the information I need. So they kind of make it up or something, or they fudge it, and it goes through the scrutiny process for the ICC, and the court's like, what the hell? No, you can't just make stuff up. You need submissions, and often they have to go back to the parties. The first thing is definitely push the parties. Now, there's a horse water problem here. If they really don't, if they adamantly refuse, then you have to come up with some solution. But you do need to push them, I think, in a way that you don't for other elements of claims. But otherwise, obviously, there's no magic to deciding interest claims. You need to decide in accordance with the parties' submissions. What you can't do is make stuff up. And there are a lot of examples of arbitrators fudging interest because they don't get it, or they've got poor submissions, or something else, and that's obviously not good. What I would say is that there seems to be a reflexive hesitancy to grant interest as damages, like real compensatory interest, where a party says, look, the classic thing you see sometimes is if a party is constantly running an overdraft, and they say, look, during the last 2 years, I've been running an overdraft of 30 million, and this is a $5 million claim, and my overdraft rate is X amount. I'd like that. But arbitrators go, no, I can't do that. And I would ask the question, why? I mean, if a party really proves the time cost of money to them subjectively, why not? It's just like damages.
Well, and that goes back to the point of doing it early, and if it's going to be ahead of damages in that way, having to put on evidence and proof and actually be talking to your client, at the outset of the arbitration, that if they're going to claim overdraft rates or cost of equity or those sorts of things, they need to actually be thinking about it at the get-go so that they can prove up the amounts claimed.
Yeah, it's true. And mind you, that said, of course, as counsel, you don't care about the nicety of things. You want to win, and you want to win as much money for your clients as possible, or defend, of course, depending on which side of the table you're on. And, even though obviously I have certain views about economics of interest, I mean, if the potential statutory rate that applies is really high, then I'd rely upon it. So, for example, in New York, the statutory rate is 9%, and it has been since 1981. Yeah. And in a number of cases where I've been the claimant and doing New York law cases, I'm just like 9%. It's like cha-ching, cha-ching. Our client will make a fortune. Like they'd be massively overcompensated, over the last 10 years at 9%. But I'm not going to complain and explain to the other party economics. Half the time they don't say anything. Whereas, in fact, if I was defending a claim against a New York law, I would say, and there's many cases who found that, is that 9% rate shouldn't apply in international arbitration. But the other side just doesn't know that.
Yeah.
So you can win a lot of money by creative lawyering.
And interest on costs awards, how often do you see that, Matt, in the research and in practice?
I mean, every party should always claim interest on costs. It's professional negligence not to, I think. And because even if you're the respondent, for example, if you have a chance of winning, respondents should claim interest on their costs, because if they win and are granted costs, and that's the only thing in the award, there's a good chance the claimant won't pay. Or even if they don't, why not just take the money? Even if they pay within 30 days and you make the client, I don't know, $5,000, why not?
Yeah. That has been such an interesting little jaunt around lots of complex sub-elements of interest. I can see that Albert is off mute. Did you have a question, or are you just no, horrified at the thought? One other comment that I just thought I'd make is that I noted the CIR guidelines, which are quite old now, on interest for arbitrators in drafting award, also recommends compound interest on monthly or 3 monthly rests. And I think it's worthwhile particularly for everyone who sits as arbitrator as well. Sorry?
Like that CIR, nobody should read it.
Well, okay. Good. All right, we'll read your book instead.
No offense to the CIR, but I've given a number of comments on that to different people. Sorry, I mean, there's some elements of it right. There are some which are actually 100% wrong.
Okay. It sounds like you've just volunteered to update that note for CIR, Matt. But I think things like, where compound interest is being claimed, making sure that you're looking at things like ensuring that the parties are making submissions on the risks at which it's going to be compounded and things like that, and hopefully doing the maths for you, if that's not something that you want to delve into. All things that, with arbitrator hats on, the earlier that we think about those things, the better as well. Mm-hmm. So there's lots of things that are now on my checklist that weren't quite as front of mind previously, Matt. So thank you for all your work on that. Did anyone else want to jump in with any questions? Leon.
Hi, everybody. Can you hear me?
We sure can.
Fantastic. Hi, Matt. Good to see you again, and thanks for that chat. Not so much a question, rather just a reflection. I was a little bit surprised by the poll results. I know it was a very small sample size, but my impression, and this is before the days right now I'm with Omni Bridgeway, which is a funder. So interest is something which is very important to us. But this comment goes back to even when I was in private practice. I would have thought that everybody in this room, so to speak, or our community understands that interest should be awarded, and not just regular interest, compound interest. I think everybody gets that. I think where the problems arise, and I think, Matt, you touched on this, is I think there's a lack of really guidance or real signposts which help arbitrators award interest, and more importantly, counsel make the submissions upon which arbitrators can then base their opinions. And I think that's where a lot of maybe lawyers and maybe even sort of experts fall down, because I have seen so many different reference points or data points upon which interest is being claimed. Now, sometimes in a contract or law, it's provided for, and that's excellent. It's a certain country's central bank rate at a certain point, and that's great. But often there's silence on that. And so where do you go? You see LIBOR. I came across another one yesterday I'd never seen before, and then you add 5 points on top of that, or 2% on top of that, and it's very sort of lick my finger, sort of finger in the air. And the arbitrators, they say, okay, it's 5%. It's plus 5%. It's plus 1% on the other side. I'm going to split the difference, make it 3. It's very unsatisfactory. And I think if there was more guidance in terms of for lawyers where they could, on which rates are reliable, are appropriate in a certain situation, then I think you'd see more counsel making more intelligent and informed pleadings, and then as a result, arbitrators making more intelligent and more informed decisions. My 2 cents, Matt. I'd be interested in your reaction to that.
Yeah, I agree. What I think is really funny is that the arbitration community tends to have its favorite toys at any given time, and at different points, different things have come up. Obviously, in the old days when third-party funding first came up, everybody had talked about third-party funding, and at different points there's been different things in terms of, now it's obviously in terms of climate change disputes and all these things. And what's funny is that this interest has never taken fire. Like, nobody has ever taken the baton and tried to run with it, to actually get people in the arbitration community to align on it, like they have on, for example, like say multi-party, multi-contract arbitration. Every institution tried to come up with the best solution, and interest just hasn't. Nobody cares. I think that's the problem.
Yeah, which is
every time I
shame.
propose things. Sorry, no.
Which is a shame. It's a shame.
Yeah, exactly. And the thing is that I'm working on a number of projects now with a number of institutions to try to improve the soft law in this topic. And and I probably do speak a little harshly of the CII guidelines. If you read those, you'll be infinitely more informed than if you don't read them. So I do encourage you to read them from that perspective. But there's also, kind of, you can read this as well.
The
Which one
time.
is quicker?
You'll need to include the link in the chat so we can click on it, and then we can hear the cash registers ringing around the world.
Exactly. Well,
Thanks, Matt.
It's 257 pages, no, 56 pages, Matt's book. So it's actually quite thin. That includes all the footnotes and everything. And it's actually quite an easy read. Slightly surprising. It does have equations in it, so watch out, but that's exactly what you'll need when you get to the appropriate point of the award drafting or making submissions. But it's very accessible and very well written for a pretty technical topic. So it's a really great contribution, Matt. Thank you very much. I certainly know where I will, my first port of call on all things interest related will now be. And from an ACICA perspective, there is the Rules Committee is currently looking at a new set of rules. So I might make sure that the appropriate people reach out to you and see if you have any suggestions on the topic of interest at the appropriate time.
It would be my pleasure.
With that, I might let everyone go. It's been fantastic to see lots of people attending today. Matt, it really has been super interesting to dig into this topic in a bit more detail. Really appreciate your time, and thanks everyone for joining.
Thanks, Daisy.
Thanks, Matt. Bye-bye.
Bye.
Bye.